Foreclosures, the REO portfolio in deeds, or purchases in satisfaction of a debt would be an accepted purchase.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
The 21st Century Road to Housing Act continues to draw significant attention across the housing and mortgage industries. The legislation addresses housing affordability and supply, borrower counseling requirements, and imposes numerous restrictions on institutional investors. I'm joined today by Friedman Vartolo partner Catherine Aponte to walk through this legislation and its potential impact. Hey, Kat, how's it going?
Good, how are you?
Doing pretty good. Can you walk us through where we are right now with the 21st Century Road to Housing Act? Where does it stand?
Sure. The Senate passed it off to the House that made an amendment, basically removing the 7-year divestiture period. And then from there, now the Senate either has to amend, deny, or modify the amendment.
The biggest thing that comes up or that stands out is this institutional investor restriction, I believe, of the ownership of single-family homes.
Yes.
Can you walk us through what that means or what it potentially could mean?
Sure. So there's a cap on how many purchases an institutional investor can own, or institutional lender, however you want to frame that, can own, and it's over 350. However, the bill defines purchases. So for our purposes or the context of the default industry, foreclosures, the REO portfolio in deeds, or purchases in satisfaction of a debt would be an accepted purchase.
If one of our clients foreclosed on 1,000 properties after they held the mortgages, they would not be restricted from bidding at those foreclosure auctions.
No.
So this is really geared towards a company that wants to buy up single-family homes.
Also large institutions, but there are businesses that own large portfolios of properties.
What if you own 1,000? You have to sell them now?
So it's purchased. I don't recall reading any retroactive piece to this legislation. Assuming that is true, then if you already owned it, there's not going to be a requirement to divest it or sell it off.
Let's say I'm an institution and this year I buy 100 homes and I sell them. And the next year I buy 200 homes and I sell them. Now I'm going into year 3. Do I have to just close my company down if my company's job is to buy and sell homes?
Well, if you're buying and selling, then you're going to drop off some from your portfolio.
You can't hold more than 350.
Yes.
I know there's something else in here about borrower counseling requirements. Can you get into that a little bit?
Sure. So right now for federal-backed government loans like FHA loans or the VA loans, there is a notice that goes out to alert borrowers of their entitlement to housing counseling if they're delinquent on their loans. Under the revision, it's going to be more than just a notice. It's really providing that opportunity to them to have that counseling.
What do you think the impact of this bill overall will be?
I think there will be a big impact of the bill. I don't think there will be as big of an impact on foreclosures per se.
Right. I mean, it sounds like if it's not restricting or foreclosing plaintiff's ability to take back property, it wouldn't have a massive impact on a foreclosing lender or on a mortgage lender who might have their lending activities chilled by the reality they couldn't bid. Like, I could see that being a really big problem. So I imagine that would not matter. I don't know if there are lots of companies that have many more properties than 350. Most single-family properties are not owned by institutions, at least not to my knowledge. So as you decrease the amount of purchasers, you decrease the value of that which they intend to purchase.
Yes, and I could see that argument. I think that's maybe one of the arguments for why the Senate had the provision in there for divesting within 7 years. But I think the House recognized that you would affect the supply and overall market, which is why they removed that provision, and it's now going back to the Senate.
If you're not stopping certain companies from buying, then this bill has zero impact. If it does have an impact, we'll have less buyers and property values will presumably have to go down.
Part of the bill is not just about the supply, but also the affordability. So that, in a sense, does make sense considering where I would say the public feels inflation is in the market. However, I think that it's designed to account for supply and keeping people purchasing.
Thank you for joining Catherine Aponte and I on the Weekly Friedman, your source to the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.